We business people put our sneakers on and run as fast as we can to chase it. And then, we lawyers with our push brooms kind of, clean up the mess.
Welcome to the brndBrief podcast, where we discuss the latest trends on the business side of fashion, beauty, entertainment, and the impact of technology on driving brand growth. This podcast is powered by Brand Method Media Group, and I'm your host, Kelly Kelly. Today's guest is Sharon Toerek, founder and CEO of Toerek Law, a national intellectual property and marketing law firm based in Cleveland, Ohio. They specialize in helping creative professionals in the advertising and marketing industries protect, enforce, and monetize their creative assets. Welcome to the show, Sharon.
Thank you for having me, Kelly. I'm excited to be here.
Wonderful. So I was really excited about this episode because I feel like the legal side of the creative side gets a little buried, and we all love the fun, kind of cool stuff, but this is a part of the business that has to be addressed by a professional. And so I'm anxious to dive in. I would love to start with your background with Toerek Law and how you got started and what made you want to specifically be in the creative space.
Yeah, well, and I totally agree with you. It doesn't feel like the sexy side of marketing to to most marketers, and especially not our clients. So I'm an intellectual property lawyer by training, and I have always loved the idea of protecting brands, original content. I think those are things that move our culture, they move our economy, they deserve protection. And so I was excited to have exposure early on in my career to sort of the legal infrastructure for how to do that. And as I ventured out on my own and started my career as a practicing lawyer, it was something that kind of distinguished me. I've always ran my firm as basically a small entrepreneurial business. And there weren't a lot of other lawyers really addressing this for entrepreneurs, and particularly in the creative community. And so really what happened is I started working more with brand owners, marketers in general, particularly on trademark issues associated with their brands. And that just sort of led me down a road of working with more marketers, and then more particularly narrowing that down to primarily marketing services firms, creative firms who work directly with brands in elevating the brands, getting good business results through marketing campaigns and things like that. And so that's what the firm does today. This is not my first firm, but I founded it about 10 years ago to really work in the creative space exclusively. And I sort of ran that business as a silo in my last partnership, which was more of a general business law firm. So we love it. We love having a front row seat to the creativity, and we love the challenge. And we know, after doing it as long as we have, how to take some of the friction out of it, so it's maybe not so painful for creatives who just want to get on to the next thing in their lives.
And that actually brings me to the next question. And just to go back just a little bit, it's interesting that you say that you started working specifically with marketing agencies. We have been asked about this before with previous clients. It's like, the conversation always comes up with how to protect their trademark. We used to be a part of brand development, and that was a natural question after we've built this beautiful logo and we've got all this messaging and we got the name and it is and that. And they're like, do you know anybody that can do a trademark? So it's the synergy seems to be pretty natural. It's just kind of, will they take those next steps to do sort of the not so fun part of it? And so then that brings me to the question, when people think of legal, they think very rigid and complex. And sometimes they can even, especially if they're in creative, they can feel like, do I really need all that? That sounds like a big company, sort of thing. How do you guys facilitate the conversation when you're dealing with, a creative driven business, and how do you kind of bridge that gap between, hey, these are the things that we have to cover, there may not be of interest to you, but how do you guys foster that part of the business, sort of the relationship building and then the ongoing?
It's a really awesome question, and I think it probably starts from believing fundamentally that your intellectual property, and that can include your brands. It can include the marketing strategies that drive the business results for your company. But they all come out of ideation, and those ideas, as expressed in either brands themselves or original creative work, that's your key inventory of your business. Next to your people, your intellectual property is your most significant asset. And I don't care the size of your business. It can be a very small upstart or it's an enterprise. Trust me, the formula to Coke is still a very well guarded trade secret. It's intellectual property. It's one of their key assets. I mean, they have others now because their brand is so ubiquitous, but it's just a big example of from the smallest of the small to the largest of the large. These are all houses built on intellectual property, whether it's a brand, whether it's creative work. And so helping the business owner and the marketers that serve them understand that and understand that it is worthy of protecting and that is their key asset in inventory is, I think, the best starting place. And once you help them understand that that's their key asset after their people in an organization, they start to understand the value of being more proactive. But I'm not going to pretend that it's an easy conversation all of the time. We happen to work with professional marketers, and they are always moving at the speed of light. They don't like obstruction. They don't like to be slowed down. And so we understand that. And it's really why my mantra is kind of earlier is better. It's better to start ingraining some of these things into your process earlier on so that you're not left at the 11th hour with a brand everybody loves, but that nobody has vetted, for example. Nobody wants to go back to the starting block after all that time, energy, money has been spent.
And when would you recommend engaging in a legal firm if you're just starting a business? When would you recommend an entrepreneur engage?
I think for when you are thinking about how you want to show up as a business in terms of your brand, and your brand is a very umbrella expression of your name, your visual and graphic representation, the way you talk with clients and treat customers, all of that is brand. But I'm just referring to the marketing assets that usually sprout out of brand. The earlier, the better, like at inception, ideally, when you are having those conversations with your corporate lawyers about what kind of entity to start up or what your partnership agreement needs to look like, all those just businessy legal issues. You need to be considering your intellectual property and protecting it from the start. And your brand is usually a key place to start because everybody has one. Every business has one. And so before you open the doors day one or open your website, whatever it might be, and then as you go, as you develop products, services, strategies, you need to integrate legal into that process as part of the ideation instead of doing the creating and then backstepping into the legal. That's what causes the frustration. That's what causes the delay. And that's what makes, we lawyers, and we understand this. I mean, I have a pretty thick skin about it at this point. It's what makes us look like big obstructionists, like we're, the big adults that walk in the room and love to say no. We don't. We don't love to say no. I love to say yes. And so the earlier you involve us, the more likely you're going to get the answer that you want in terms of whatever your plans are.
Now, you've mentioned a couple of times marketing strategies, creative. My guess is this is beyond trademark, which I feel like is probably the one thing most people at least think they need. What are some examples of other things that should be protected?
Well, if you are relying, for example, on content creation as part of your business growth strategy, protecting that original content, whether it's words, pictures, video, and if you are a business that is built on selling content, for example, a coaching company, a consulting firm, those are assets that as you develop them and are monetizing them, selling them for cash, they need protection in and of themselves. So once you're beyond the brand, it's what are the words, pictures, ideas, and other stuff we're using to put our message out into the world. Those are all creative works that you need to think about in terms of perhaps copyright protection. I like to use a framework we call the triangle at our firm. It's brand, which we've already talked about. It's content which usually invokes either copyright or sometimes patent protection if it's, an original invention, for example. And then the third point of the triangle is your transactions, and those are the contracts you need to be thinking about that protect your intellectual property.
As we're sort of knee deep in AI, is there anything you can speak to about how to protect words or images that you generate from some of these, Mid-Journey or Chat GPT? Is there anything you can speak to about, just high level, what that looks like? Is it possible? Does it get more complicated now?
So high level, the position of the Copyright Office, as you and I are speaking, Kelly, March of 2024, is only human created work is entitled to copyright registration and protection under our copyright laws. So it really depends upon the extent to which you can separate the AI generated content from the human created content. Because the truth is, most content that's seeing the light of days these days on behalf of a company is a bit of both, right? It's not, nobody's spitting something out of an AI platform and just saying, here, run with it. It's a hybrid. And so there's precedent for the fact that if you can segregate, the best example is a graphic novel where the illustrations were created by Mid-Journey, but the words are human authored and the arrangement of the illustrations was human created. And so the Copyright Office sort of ultimately took a divided approach where you could protect the human provided elements and not the machine generated stuff. And so it's really a question of how much human interface with the content happened before it sees the light of day. And so I think to be safe, you have to assume that if you've used AI to generate content, it's going to be tricky to protect it over time. And so if owning the IP rights in that is something that's important to you, you need to think really hard about how much you integrate AI created work into the final asset.
It's really
It's
interesting.
frustrating is what it is for most marketers I talk to, but it is where we are right now. It's the
I
state of
had to
things.
ask because it
Yeah,
seems to be, I've seen it come up. We don't, as a firm, we don't work with coaches right now, but I have a lot of colleagues who are, and I see this question come up a lot in, Facebook groups or message boards, like, how do I protect this new program I've just put together? And you can never get a clear answer sometimes from the comments, but I definitely want to ask you that because it's a question that's on a lot of people's minds as we're all sort of in this bucket together. Now, you made sure to mention, this is March 2024 and the Copyright Office says, obviously things change at the
right.
speed of light, especially when we're dealing with content. How do you and your team stay up to date on new and emerging things, maybe ahead of your clients coming to you so you can be ready? Because they're going to come to you with questions and say, well, how do I protect this? If you guys aren't keeping up with that, you're probably like, what is that? How do you guys stay up to speed on emerging trends in the content space to be able to service from a legal perspective?
So part of it is doing our best to monitor what the Copyright Office itself is doing. That's an administrative body. It's not a court of law, but they are the deciders really of what will go past their gates in terms of being able to register a copyright. Other than that, we are doing our level best to keep up on all the case law these proceedings are just starting, so we don't have any precedents yet. There are lawsuits pending right now from famous creators versus OpenAI, which, was the creator of ChatGPT. And we don't know how they're going to develop or come out. So far, what we're seeing is some licensing deals that are being entered into between content creators like the Associated Press and OpenAI so that there's a license arrangement between them. But then we've got New York Times suing OpenAI, and they clearly negotiated for a long time before that happened and were not able to get to terms. So my theory is New York Times is either going to push it to the wall to see what the courts say about owning copyright protected work and having it being fed into something like ChatGPT, or they'll enter into some sort of license agreement after a certain part of time. But we just have to follow it as best we can, set alerts, treat it like the news event that it is. And I think the hardest thing for creatives to understand, no matter what kind of business they own or run, is that Legally, we're not really treating generative AI like you treat any other implement you would use to create content. It's not like using a camera or a piece of software, because I get that question a lot. Why is this any different than any other tool we use to create content? And I don't have a good answer for that, except for that these machines are getting so smart and their data sets are growing so quickly that they're just not being treated on a level that any other tech tools we've ever used for content creation. So we just, the law always sweeps up behind. Technology runs in front. We business people put our sneakers on and run as fast as we can to chase it. And then, we lawyers with our push brooms kind of, clean up the mess. And that's never going to change no matter how quickly the technology develops, unfortunately. You just have to kind of stay nimble about it and have human guardrails in your businesses about which platforms are acceptable to use, which are the use cases that you're comfortable with. Are you comfortable using it just for research? Are you comfortable using it for first drafts or outlines? Who has to approve it before it goes out? Look at your policies, have crucial conversations with your clients around this to make sure you're all aligned on your policies around using generative AI. And for now, that's really the best you can do from a legal due diligence perspective.
Yeah, a few years ago, I was in-house doing digital marketing for a law firm. And listen, to get a post out was like, I mean, it had to go through a lot of, which I understood obviously in that industry, but it was not like working with a clothing brand or a candle. It was like, this needs to be submitted to this department and cross-reference. And at the end of the day, we don't know if this is okay. So no, don't post. It got crazy.
Right. And that's a really good point, because that points directly to what's your risk tolerance. My experience level with marketing services firms is that they are a little more comfortable with risk than other types of businesses. My sympathy to you for working in a law firm in marketing, because I know exactly what you were up
Nope.
against in terms of risk tolerance. So, that's why I say have a conversation with your clients or internally as an organization if you're a large company. Are we all on the same page about the risk we might be assuming? Are we okay with putting something out there that we probably don't own completely? And who's approving it? Who's deciding? You need to have those big conversations if you're going to seriously integrate AI into your content creation or your business operations in general. And so it should be a collaboration between the people in the business who need to be talking about those things.
Yeah, totally. So before we check out, I wanted to ask about what you guys have coming up. Is there anything on the horizon that Toerek Law is excited about that you guys have in the works?
We are excited about the uptick we're seeing in, our client world is professional marketing services firms. We're excited about the uptick we're seeing in collaborations between these firms. We've seen M&A activity go up a little bit, and I'm not talking huge transactions either. I'm talking, small business to small business, a lot of conversation around putting businesses together and combining efforts. And so we're excited about the exponential power you can create by putting maybe two like-minded firms who have different skill sets together to serve a common client or purpose. And so we're creating solutions around that I'm pretty excited about. We actually just did a Q&A session around that. And so I'm excited about that. I'm excited to see where AI goes. I mean, as challenging as it is to have to say it depends to a client, which is their least favorite answer to a legal question, hopefully we'll start to color in some of the lines a little bit as, the months progress this year. And so I'm excited about that. Got a couple upcoming conferences that I'm going to be speaking at, which I'm also excited about, mostly in the marketing services industry, but also at the Creators Expo, which is
Yeah.
a conference in early May being held in Cleveland, Ohio, which happens to be my hometown. So that worked out really well for me, about the business of content creation. And so I'm excited about that too.
That's amazing. I'm so glad that we had a chance to talk. I feel like we've discussed some things that are definitely kind of nagging in the background. And I
Yeah.
think people in creative spaces need to just take more seriously It may not be fun. It may not be how you want to spend the afternoon, but it is super important. So thank you so much for your time. And we're going to drop a link to the site. And if anyone wants to get in touch, we'll have that available. Thank you to our incredible guest, Sharon Toerek, founder and CEO of Toerek Law. If you enjoyed today's episode, please like, subscribe, and leave a review. We'll see you next time.